You know, it's like somebody doing a PhD. You do literature review. So it seems to me that the judges went in past judgments and tie all their decisions to either apex court or court of appeal decisions. And that is in sync with those principles. So for me, as somebody, we are all educated, it seems to me that it's very thorough. You did a wonderful job. And I was telling the Attorney General that the work of these judges is really not easy. You can imagine all the corresponding cases that you are citing, going through. So it's a lot of work for them. And I'm really, really impressed. Like I said, as a Nigerian, I'm very, very, very proud of our team. So, well, we are doing our job, we just keep going. Remember, the election took place months ago. The people of the state voted months ago. So that for us is the most important. The ability to convince fellow citizens, the Russians, on what we intend to do. So those are the things we must focus on. So we will not be distracted by this. It's important. It's part of our process. In my view, it improves our democratic credentials. However, we must do what we have to do. And that's what the government and myself and the cabinet, that's what we are doing. Satisfying the needs of the Russians.
Learned Justice of the Court of Appeal reviewed extensively the provisions of the Constitution of Nigeria. And I must say, with all due respect, I agree with their decision that apart from you making an allegation, the way we analyze things in the tele, in the social media, is different from the way the court process will take place. And you should take home what the Justice of the Court of Appeal said, is that a petitioner, a litigant, must succeed on the strength of his own case, not on the weakness of the defendant. He who alleges must prove. Is that if you allege anything forgery, that means it's a criminal offense. And by our constitution, criminal offense must be evidence act, must be proved beyond reasonable doubt. That means you must have tried somebody for having committed a crime, and there's a judgment to that effect before you can say that person has committed that offense. And the team of our respondents in this case have been consistent. The rule of law, the Evidence Act, the Electoral Act, and the regulation in which all of us as litigants, especially in election matters, must comply with. There's no shortcut to it. We have always said election proceedings, election petition, and sui juris. So what applies in ordinary civil matter may not also apply. So like this time now, you are aware that for you as a petitioner to come to election petition, you ought to front load what you said as at the time you are filing your petition. Don't forget, this election you have about 21 days after the election has taken place. For 21 days, you should know the type of witnesses you intend to call, whether supreme witnesses or unsupreme witnesses. You front load their names and the document you need to tender, unless you can show to the tribunal that those documents were not in existence as at the time you are filing your petition.